Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations, within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. Joining me on panel for the 5 cases we'll be hearing this morning are Justice Mary Sullivan and Justice Vicki Henry. We did have one case report settlement yesterday and drop off the list. All of the cases today are civil matters. We will be going through them in order without a recess along the way unless something happens. We are back into our virtual hearing mode using the Zoom platform with a live stream to YouTube for public access due to the pandemic. And I again want to express my gratitude to our dedicated clerk's office staff and our IT support staff that have made it possible for us to continue our operations despite the challenges of the pandemic. The first case on our list, I want to mention, as I do for all of these virtual hearings, we have our equipment is equipped with cameras. We will be looking at the cameras, but the iPads or other screens that we use for access to the content concerning each case are off in a slightly different direction. And if we glance away from the camera from time to time to consult our notes, it's not that we are doing other things. We are simply getting access to the materials we need to focus on this case. The first case on our list for argument this morning is case number 2021 P3, John Doe number 526050 versus the Sex Offender Registry Board. Ms. Hernandez.
Good morning. May it please the court, Attorney Xiomara Hernandez for the plaintiff appellant in this case, John Doe. As you know, the Sex Offender Registry Board classified my client as a level 3 sex offender. I'm here today requesting that this court remand the case back to the board for another classification hearing, as the hearing examiner decision was arbitrary and capricious as he committed multiple errors within his decision. First, I would argue that the hearing examiner erroneously found that my client raped his cousin's 15-year-old son in 2010. I assert that this was error, as it was based on unreliable, multi-leveled hearsay evidence of information that Doe allegedly shared with his friends, and his friends in turn shared it with the police. There was no direct statements from the alleged victim himself or from my client. There were no witnesses. There was no police investigation. There was no report, and there was no charges filed. And I would assert that
Counsel, we have, though, 3 different people who reported that Doe had said this, and then for 2 of those people, there was some corroborating detail where they either helped him write an apology to someone, or they saw that he was video chatting with young boys. With all of those attendant circumstances, can the hearing officer still not credit this?
I would argue that more is needed under these circumstances for the hearing examiner to credit this multi-leveled hearsay evidence. My client also shared with a couple of his friends that he didn't commit the index crime. And, I believe the court would assert, and also the hearing examiner would assert, that he did in fact commit the index crime. So I think the hearing examiner should not have based it solely on what those 3 friends told the police, and then in turn the police reported in the police report. More should be required under these circumstances.
Let me be sure I understand your argument, because it's unclear to me whether you are suggesting that evidence was impermissibly admitted and should not have been considered at all, or whether the hearing examiner gave it undue weight.
I believe it shouldn't have been admitted under these circumstances. So hearsay evidence is allowed in these type of hearings, but it has to be reliable. And I would say that
who makes the determination on the threshold gatekeeping question of reliability, and what is our standard for review of that decision?
Well, the hearing examiner would be the one to make that decision. But I would assert that is under these circumstances.
We defer substantially to the discretionary call if there are indicia of reliability that a rational person could accept, correct?
Unless you were to find that making this, indicating that this is reliable evidence was an error, that it was, arbitrary and capricious for the hearing examiner to make this finding.
But then if we conclude that the evidence was not an abuse of discretion, that it wasn't an abuse of discretion to accept that evidence, then our review of the ultimate determination of whether he committed the index crime, that's substantial evidence, correct?
Correct. Correct. And I would also say that as a result of the hearing examiner erroneously finding that my client committed that offense in 2010, that he went on to apply 1 high-risk factor and 2 risk-elevating factors. So just in the totality of the high-risk factors that were applied here, there were only 2 high-risk factors that were applied. And if you were to take away one of them, then, that just doesn't lead, in my opinion, it's just an error to have done that.
Mr. Mendez, you have not in your brief lodged a challenge to the hearing examiner's consideration of factor 2. I don't remember the precise timing on your brief, but you are aware, I'm sure, that that factor has been ruled impermissible, unconstitutional, and the board has elected not to challenge that ruling and has taken the position that it will concede error on those cases going forward. Your brief was filed before the Wilkins decision, I take it?
Actually, unfortunately, it was filed a few weeks after the Wilkins decision. I should have filed a supplemental brief, or should have caught that when I filed the original brief in this case, but I didn't. But yeah, as you indicated, that part of factor 2 has been ruled to be, the SORB had exceeded his statutory authority to apply that part of factor 2. So I would assert that this court can, if it wanted to, even though I may have waived it, can, if it wanted to, take out that, find it that it was error for the hearing examiner to apply factor 2 under these circumstances. And I would also, yes.
On that score, could you clarify for me what the timing is between the charged offense and the uncharged offense when they occurred?
So the uncharged offense occurred allegedly in 2010, and the index crime occurred in 2002. However, apparently he didn't tell his friends until around 2013 or 2002 regarding the uncharged offense.
And remind me, is it the 2002 charged offense where the boy woke up and caught him?
So that's 2012. Yes. Yeah, so that is the index crime.
Oh, it's 2012.
I apologize. So the 2010 is the uncharged one, and that's the one where he was, the 15-year-old boy was drinking and apparently had passed out on the couch. Yes, that's correct.
So the offense where he was caught occurred after the uncharged conduct.
Correct.
Okay.
Correct. Okay. And I would just, there are other errors also in the hearing examiner's decision. If you look at factor 19, level of physical contact, the hearing examiner found that applied this risk elevating factor. And if you read it, it indicates that it should be applied when there is penetration. Sexual assault involving penetration has been shown to cause increased psychological harm to the victim. The offender who engages in penetration, especially penile penetration, as part of the sexual offense poses an increased degree of dangerousness. In this case, there's no allegation there was any penetration. Additionally, the hearing examiner erroneously only gave minimal weight to risk mitigating factor 28, and that's supervision by probation or parole. And as you know, my client was in fact under probation, and there was evidence submitted that he was in total compliance with probation, has never violated the conditions of his probation. So I assert that instead of minimal weight, the hearing examiner should have given this risk mitigating factor full weights. There are a couple other errors. Let's see if I have time. So also the hearing examiner erroneously only gave minimal weight to risk mitigating factor 33, which is home situation and support system. In this case, you'll see that my client had the enormous support of many family members. And in fact, at the classification hearing, his brother and his sister testified on his behalf, indicating that they are aware of his conviction and that they have chosen to support him. And lastly, in terms of the errors,
can the hearing examiner give weight to the notion that the family seemed to be in denial about him committing the index offense?
Well, I mean, so the hearing examiner chose to give this minimal weight. I would argue that even moderate weight would have been fine, maybe not full risk mitigating weight, but moderate, because again, he had the tremendous support. Many of his family members and 2 of his siblings chose to testify the classification.
The support is not quite so tremendous when they refuse to acknowledge that he committed the offenses.
Well, support in terms of just supporting him being, being alive and supporting his being able, yeah.
All of that is admirable, but in terms of risk mitigation, to the extent that they refuse to acknowledge or accept the premise that he committed these offenses, how vigilant are they going to be in acting to ensure that he does not reoffend?
I mean, his brother did testify that he's given him advice to make sure he's not in a room alone with, especially with a young boy. I mean, that under these circumstances, I would say that's good advice. And in terms of denial,
or is he going to be ensure that he's present?
I'm sorry, say that again.
He's advised him not to be in a room alone, or or the brother has said that he will ensure that he will be present at any time that situation might arise.
I think the advice was for him not to be alone in a room. But that being said,
that the offender is drawn to this type of behavior. I mean, part of the whole concern here is that impulse overwhelms the advice he may get from others.
Yeah, I mean, again, I think that maybe the hearing examiner could have applied maybe moderate weight, maybe not full risk mitigating weight to this factor, but moderate weight, because the hearing examiner already took into account the denial of my client in terms of applying, him being involved in sex offender treatment, because my client at one point did deny committing these offenses. So I think that's where denial more appropriately should enter the equation here. Also, the hearing examiner erroneously only gave moderate weight to risk mitigating factor 34, which is stability in the community. And as you'll see, my client has been in the same apartment for 6 to 7 years. During that time, he's had no issues with the landlord, has actually helped around in terms of the property. He's helped in the laundromat. Also, he has stable income where he receives SSDI for his Tourette syndrome. And I would say that also just under the totality of the circumstances of this case, I would assert that if my client poses a danger, is a low risk of reoffending. As you know, his index crime was his sole criminal conviction. It was committed almost a decade ago, and he hasn't reoffended. He is getting up there in years. He's in his 50s now, and again, hasn't reoffended. During the time of probation, he was involved in sex offender treatment. He was active, and he participated in all the meetings. He was in full compliance with requirements of his probation. Again, as I indicated, he had the love and support of many family members, and also he had a pretty stable income and pretty stable housing situation. And lastly, I would argue that this court should remand the case back to the board because the hearing examiner failed to make findings as to why internet dissemination serves a public interest, a public safety interest in this case. And if there's no further questions, I'll rest on my brief.
Seeing none, thank you for your argument.
Thank you.
Attorney Chennai, we seem to keep having this conversation.
We do, Your Honor, we do.
What
I
can you
think
tell me about factor 2 here?
I know what you're talking about. I saw it coming. I think, again, looking at 22188, the first stage of the analysis is if you take factor 2 out of the equation, would this individual be a level 3? If you feel that he wouldn't be a level 3, then of course you would remand it to the board for reconsideration. If you think under these circumstances, he would still be a 3 even without factor 2, then you could make a decision on this matter, obviously.
Why is that a question for us to determine what we think?
Because the courts have said Doe 22188 specifically said when there's an error in the application of a factor, the court does have the ability, if they want, and I'm not telling you what to do, but you have the ability to omit that factor and look at the remaining factors to decide whether or not there's sufficient evidence to support the classification that's presented to the court at that time.
Right. But as you know, I mean, not all factors are created equally on this concern. And when we look at the concern for impulse control and repetitive behavior, factor 2 looms fairly heavily, doesn't it?
It does, but again, in this circumstance, you've got an individual who all indications are has an obsession with teenage boys, and more importantly, has acted out on those, and just even the little things, buying teenage boys alcohol. He's telling individuals that he does have a predilection for teenage boys, that he is sexually offended that we know of against 2 teenage boys after getting them drunk so that they passed out so that he could take advantage of them. These are things that indicate that this individual is an individual who is at a higher risk because there's no indication he's addressed these issues. His support network clearly doesn't believe he committed these offenses. He's living in the same environment that he was living in when he committed the offenses. So I think that there's an indication here that this individual goes beyond the level. I mean, factor 3 alone shows that he has some kind of deviancy towards these teenage boys.
Mr. Chennai, you've seen enough of me to know that I have a fairly high level of humility when it comes to what I think I might know. It just seems to me that it would be presumptuous for me to substitute my assessment of these questions for the expert who stands in the role of the hearing examiner. Obviously, I don't know the demands on the board at this time, whether there is a tsunami of cases that require the resources of the hearing examiners. But I am drawn in these circumstances to the safety and prudential approach of I understand the argument, but why in the world wouldn't we put that question to the person with authority to make that determination with experience in doing so, rather than substituting our judgment instead?
Well, Judge, I have to say that there's many times I'm in front of this court that I even have a higher humility for what I don't know. But more importantly,
I've always appreciated that. It's a pleasure to have you
here. Again, it's a judgment call. The courts have said in the past, you do have the authority to go forward, but I'm not going to tell you have to go forward. Obviously, that's something you should decide to do. And I, again, humbly would never tell you what to do or not to do. If you feel uncomfortable with this situation, then by all means, it should go back to the hearing examiner.
It just seems to me, Mr. Chennai, and this goes across the entire field of administrative law. We extend substantial deference to administrative agencies, and we do that for a reason. And the flip side of that, it seems to me, augurs in favor of letting them tell us what they would do if a significant factor is removed from the equation, rather than presuming to do it for them.
I understand what you're saying, Your Honor. Keeping in mind that I represent the board, and this is the position the board has taken on this case. And so I'm putting forth the board's position. Again, the final decision is obviously up to the panel as to how they want to handle this circumstance.
Well, you've made the strongest argument you can for the reasons why this offender in particular on these facts should be a level 3, even with factor 2 out of the equation. I take it similar considerations apply to the internet dissemination without hearing from the hearing examiner on that as well?
Yes, Your Honor. Again, if you accept the proposition that this individual poses a level 3 danger, even without factor 2, I think the circumstance of this case is if individuals who have teenage boys living in the same community as this individual, this plaintiff, should be aware that he is there and that he has had these issues with teenage boys, it may indicate how they would supervise their children at that time. Again, this individual has sought out teenage boys. He's bought them alcohol. He's talked about his predilections to teenage boys. And I think that's important in the analysis of whether or not internet dissemination would serve a public safety interest in this case.
So, counsel, on the alleged other victim, the uncharged conduct, it seems like it's possible quite easily to identify who the alleged victim is. Why should the hearing examiner rely on this hearsay from, going from the defendant's friends to the police to being relayed to the hearing examiner when it's determinable who that alleged victim is?
I'm not sure. Are you asking why they didn't go to the alleged victim or?
Yes, I mean, it'd be one thing if it was an unknown victim, but where we can see who the victim is, why should we not require that?
I think that the board puts on a documentary case, and then it's decided whether or not the evidence is reliable for the hearing examiner to rely on it. Whether or not, I mean, we're not an investigative body. We don't have the individuals who go out in the community and interview witnesses or anything of that sort. So as an agency, we're not equipped to do that. So we take the documents that we get, and again, under administrative law and under our regulations, this type of evidence is admissible. It comes down to whether or not the hearing examiner can determine it's reliable, whether it's reasonable to rely on it. And you look at the factors involved, such in this case, as you have not only consistent statements by him to 3 different people, but you have corroboration in the roommate who said he sat with him and worked with him to send apology letters to the boy's mother, his cousin. And the corroboration is, again, Doe 3177 says that where a sex offense is unproven at a trial, a hearing examiner may consider the facts of that underlying charge or offense if the facts are proven by a preponderance of the evidence. So it comes down to whether or not this evidence is reliable and whether it meets the preponderance of the evidence standard. And the board's position, of course, is in this case, there was just too much consistency between the statements of the 3 witnesses and the fact it was independent corroboration. And finally, that it was similar to his 2012 sex offense in its perpetration.
Counsel, the apology letter, was that a hard copy letter or an email?
They were emailing on that, but
All
it was an eyewitness saying that he sat with him and worked with him and sent the messages out to the cousin. So
I understand. I did think it was email. Well, but my review of the record didn't show that those emails were in the record.
no, they would only be in the record if the police did an investigation and seized those emails. There's no evidence that they ever did that, so we wouldn't have that. Again, we're not an investigative body. We take the evidence that's given to us. So there is no
Well, is there
any copies of that.
Is there anything to prevent the agency from requesting copies of those things?
Well, we request copies from all of from all the agencies of everything that they have.
I understand. I'm asking a different question. What's in the world of corroboration and reliable hearsay, the slam dunk in this case would have been the emails. Is there anything to prevent the agency from going to the source of those emails and asking for copies of them?
Well, I think if we went to the plaintiff and asked him for copies of it, we may be violating Fifth Amendment privileges.
I'm not talking about the plaintiff. I'm talking about the recipient.
As far as we know, we don't have the name of the recipient. We just have the information that was provided to us. We know it was his cousin's son. That's all we know. So there was really nobody to reach out to. But generally, again, the board's not an investigative body. We wouldn't have probably done that. If we could establish there was a victimhood and we had a contact through the victim witness portion of the board, we could have made those inquiries. But again, that part of the case never reached that level.
And when you say that SORB is not an investigative agency, I think we've had this conversation before too, but I just want to make sure I understand the board's position. Are you saying it's not authorized, it's not permitted to be an investigative agency, or that is not within what it does as a matter of operating procedure?
I think it's a matter of what it does in operating procedure, because we don't have the resources or the individuals or finances to do that. I think that our agency is streamlined to take in all the reports we get from investigative bodies such as the police, state police, courts, DCF. Those are the records that we get and we rely on. And I think if you look at the statute, it infers that that's what our role is, in the sense that it states that all these agencies are to provide us with all the records that we need.
There's nothing that would prevent you from requesting that information if you could identify a potential source to provide it voluntarily. Obviously, the question of subpoena powers is entirely separate from that.
Correct. Theoretically, we could reach out and try to get that information. But again, the board generally relies on the documents that they receive and then decide what the reliability issue is. Now, there are times when I'll see on a police report that someone was arrested, say, for an OUI a year ago, and I will contact the agency and ask them to get a copy of the police report, get a copy of the docket sheets on that. But that's pretty much, the limitations of where I would, as an attorney, request the board to do. At least that historically, that's what we've done.
Yeah, it's just that in this case, you had a named victim for the index offense and their familial relationships. It probably would have been discernible who was involved, who was the alleged victim of the uncharged conduct. But I take your point. I understand your position, and thank you for answering my question.
So Doe argues that factor 33 about family support, that there's no requirement that the level of support be different at the time of the offense versus at the time of the classification. That the question is just family support. What do you say to that?
I say you have to look at these factors in a common sense approach. If he's got the same support system that allowed this behavior to occur originally, and they're not, and again, looking at the fact that they don't believe he committed the sex offenses and that they feel he should have access to children, their own children, I think that in that circumstance, using a common sense approach, how strong is that support system? How are they going to prevent him from, that's the whole idea of the support system. It's a support system that's going to help him from doing these things again. As Chief Justice Green pointed out, the impulsivity of this individual, how are they going to restrain that? And there's no evidence that they will or won't. It's kind of like it's exactly like the current probation. It's a common sense approach. The current probation is to show, probation is supposed to be a deterrent because while you're on probation, you're going to abide by its rules. If he's getting off probation a month after the hearing, it's kind of a wash at that point because he no longer has that protective layer of probation that would stop him theoretically, or at least hinder him from impulsivity in this area. So again, looking at it in a common sense way, just because he has family support, you have to look at what kind of support that is and what it's going to do to, especially in this individual, prevent that impulsivity in the future. And I think I've addressed pretty much every issue in this case on in my brief. I would, if there's no other questions, I'd be happy to rest on that.
Seeing none, thank you both for your presentations. The case is submitted.
I decided to reboot it again.
Good.
The case is now being recorded.
The next case on our list for hearing this morning is case number 2021P214, Philip King versus Antonietta CERBONE. The case is partially impounded. I'll just remind counsel that the presentation is live and open to the public, and please refrain from reference to any of the impounded material. I also will remind everyone watching, as well as counsel, that our screens for the Zoom argument are directly in front of us, as is the camera. Our notes typically are on other screens, whether a separate monitor or our iPad or both. And if we are glancing away from the direct sight line with the camera from time to time, it's to consult those materials and not to consult Amazon or any other third-party service. So with that, Mr. Derlin, you may begin your presentation.
Chief Justice, Justice Sullivan, Justice Henry, Mr. Herrick, good morning. As you indicated, I do represent Antonietta CERBONE. This case emanates from a divorce, a typical divorce, where the marital estate was divided after trial, and then was sort of generated in contempt proceedings, which were filed approximately 8 months after the judgment entered. The gist of the appeal centers on three different arguments, which your honors are aware of. In my brief, it really focuses on the disposition of Mr. King's federal pension and how Judge Black addressed that in her contempt judgment.
So counsel, on the federal pension, the husband argues that the divorce judgment originally was silent on what happens upon if your client predeceases the husband. Is he right about that?
Well, yes, Judge Giordano, who was the trial judge, she didn't specify the language that was to be used in either order necessary to divide the parties' pensions, either my client's private pension through her employment at Mass General Hospital or Mr. King's pension through his employment by the federal government. I dare say, in passing, I will say that's not uncommon. I don't think trial judges often sort of micromanage the division, because that does occur by the separate orders, as you're aware. So
right,
it is.
This is where it seems like we have an apples and oranges problem, or we need to at least figure out what we should be comparing. And you seem to be arguing, as you just did, that we should compare your client's interest in her husband's federal pension to his interest in her private hospital pension. But he's arguing that's not the right comparison, that we should compare his interest in his pension to her interest in his pension. And how are we supposed to tell? But one difference I see is that there's a federal regulation that says what happens if there's silence in the divorce judgment.
Yeah, the code section you're referring to, Justice Henry, is 838-237. And that does say when silent, in that subsection A in that code section, when the judgment is silent, it does give directions as to what can happen, but there's a qualifier in that section.
Actually, let me intervene here. The regulation does not refer to the judgment. The regulation only refers to a court order acceptable for processing. And several of the commentators who have looked at the federal system as compared to the private sector system, where instead of a co-op, you have a quadro, have described the regulation as a trap for the unwary, because it is a guide to the ministerial application of the co-op in the event that there's silence in the co-op. I would like to concentrate on what the rule, how we interpret the judgment, which is a different question, and which the federal regulations are quite clear that OPM and the co-op process doesn't have anything to do with interpreting court orders. So I'd like to, if we could, reframe Judge Henry's question to how do we interpret an order whose stated rationale is equal division? And
Okay.
in addressing that, I would also like you to describe for us, to clarify on the record, whether I know that the TSP, the federal TSP, Thrift Savings Plan, is a defined contribution program. Are the wife's pensions that are divided to the husband defined benefit or defined contribution plans?
It is a classic defined benefit plan through her employment at MGH, if that is what you're asking, Justice
All right.
Sullivan.
Right, but
okay.
in a private plan, correct me if I'm wrong, the parties, the law permits the creation of a separate interest quadro, not a shared interest quadro.
Correct.
Do we know from this record whether or not the MGH plan was divided as a separate interest or a shared interest quadro?
Well, on the record, the expert or the individual that the parties jointly hired to divide the pensions did prepare orders for both pensions. And so they were divided.
I can go back and look at it and see if it's a shared interest or a separate interest quadro, but
Well, no, to specific answer your question, the private pension would be divided separately. That would be a separate interest that each party retained. And it would be a done deal, if you will. The federal pension, and I allude to this in a footnote, I think it's footnote 8 in my brief, the federal pension is somewhat idiosyncratic in that there is this ongoing shared interest.
yeah, they don't permit separate interest quadros.
Right, and that is why Judge Giordano in her judgments and in her findings made reference to the fact that there must be a survivor's annuity designated so that my client would retain her income stream, if you will, or her interest in the event that Mr. King died before her. That would not be the case for the MGH pension that was divided. But oddly enough, in this situation, the reverse wasn't done by Judge Black. So we have a one-way street that occurred here, and it occurred in the context of the contempt. And so
well, it seems to me that that's I'm glad you mentioned the contempt, because it seems to me that we have really two layers here, right? The first is how do we interpret the judgment either to authorize, require, or intend the 50-50 division, including the survivor benefit, and then the question of whether that interpretation constitutes a clear and unequivocal command, so that the proposal to do it in the way that the wife proposed constitutes a contemptuous action.
Well, Chief Justice, on the contempt issue, my client was not tasked with any obligation. As you know, that task was given to Mr. King. And, you know, she was criticized ultimately for the joint expert that the parties hired and for the language that individual imparted. And that's where I think, I don't want to dwell too much on the contempt, but that's where I don't think she should have been found in contempt.
Contempt is a pretty significant element of this appeal, right?
Well, it is, yeah, ultimately. But from, you know, generally speaking, my client's more, I mean, from her perspective, she's more concerned about the designation under the co-op and what Judge Black requires insofar as her shared interest in the FERS pension. Right. But clearly, she doesn't believe she should be found out. She should have been found in contempt.
Yeah, you still have to leap over the contempt barrier, and no matter what. And I suppose that one of the questions that we have before us is whether, when the judgment is silent on the question of the wife predeceasing, whether or not there's any clear and unequivocal command. But the Judge Black also seemed to think, for lack of a better term, that your client had hijacked the quadro process by submitting a one-sided quadro and held her in contempt. I can't really tell whether Judge Black held her in contempt for the content of the quadro or the claim that she hijacked it.
Well, I think that's a problem, Justice Sullivan. I mean, I think I do allude to that. But, you know, in terms of commandeering the process, on this record, there was no evidence that Mr. King did anything that he was obligated to do insofar as the preparation of the orders was concerned. And again, he was tasked with that obligation.
Well,
and then
wait a minute. I'm not sure what he was tasked with in the judgment. Typically, when either a co-op or a quadro is done, and if you take a careful look at the federal regulations, they talk about what the obligations of each party are. The husband obviously has to clear the way for there to be sufficient information to divide the pension. But the obligation to submit the pension is the wife's, to ultimately to OPM.
That's not what this judgment says, though. This judgment puts the onus on him. Well,
it says
I dare
to cooperate. It also says that both parties shall submit the quadro.
Well, that is true. That is true, but he was tasked with the obligation to effectuate the orders. She was tasked to cooperate with the process, and she was ultimately found that she didn't cooperate. But insofar as commandeering the process is concerned, she, in her responsive pleading to Mr. King's contempt, she indicated she had hired and consulted with this third party. So Mr. King was aware of that. Then in September of 2019, at the contempt hearing, he stipulated to using her. And then when it came back on a review in November of 2019, he was unhappy with the language that she had prepared. But that is not my client's commandeering the process. That's Mr. King being unhappy with the work product that this individual, prepared. I don't know how that can be.
Why wouldn't the quadro have had alternative language in it? This is what the wife proposes. This is what the husband proposes.
Well, on this record,
And let the judge rule.
I guess that could have been an option, but that's not what happened here. And
just out of curiosity, go ahead.
I just have one other question. Attorney Herrick says that a lot of these arguments are waived because you haven't given us the transcript of the contempt hearing. I believe you've got a representation in your brief that there was no evidence taken at the contempt hearing, and we can look at your papers. Is that correct, that there was no evidence at the contempt hearing?
That is correct. My understanding, based on my conversations with my client and trial counsel, I was not trial counsel. It was a 10 to 12 minute.
Did the parties make any representations?
Well, I think there was discussion by the parties through counsel, through representation. And Judge Black, not surprisingly, felt that this issue was complex enough that it required a Rule 78 memo. And that's what she ordered to be filed.
I'd like to defer to Judge Green, who's been Chief Justice Green, who's been very patient.
Well, no, I just wanted to get a little bit of insight into the progress of this case, because as you mentioned earlier, Judge Giordano issued the original judgment that gave rise to the questions that we're now wrestling with. And then Judge Black was the judge that picked it up for the contempt. Why was the case transferred? When we're trying to get insight into what the judgment was designed to effectuate. Why
she went out? Judge Giordano went out of county. She now sits in Suffolk County. So I think that's the reason.
So she simply transferred to a different county. It wasn't as though she retired or was otherwise unavailable.
No. She continues to sit in Suffolk County, and Judge Black in Essex County assumed her docket under the individual calendar. I mean, that's the short answer.
That's a different way of using an individual calendar than some might imagine. But that thank you for the explanation.
Okay. So, I mean, my view is that my client's discretion to direct her interest, her shared interest in the federal pension, was taken from her through a misunderstanding and a misapplication of the applicable codes. Justice Sullivan, you alluded to this earlier, and that is 837 or 838, 237, sections A and B. They do not prohibit, the way Judge Black seems to have concluded, that the reversion must go to Mr. King. That is not what those sections provide. There's qualifying language, and it's certainly consistent for my client to be given the right under the standards pertaining to divisions of assets, and given parties of any asset the obligation, the opportunity, and the right to direct that asset as he or she sees fit. That is not the case in this situation. Understanding that it is a shared interest, I acknowledge that, but ultimately the regulations that I cite in my brief do not prohibit the spouse, such as Ms. CERBONE, that is the recipient spouse, not the employee, to direct a beneficiary other than the employee, and that is.
Since it is a shared interest quadro, do you agree that the ex-husband, Attorney Herrick's client, is permitted to elect a form of benefit of his choosing at the time of retirement?
Well, but for the fact that it does require 50% shared interest, I allude to that also in a footnote, because the word maximum was taken out of the quadro. I will say that the judgment.
Are you still promoting the maximum argument, or have you dropped that on appeal? Or are you?
Well, okay. To answer your question, I think it would be certainly it would be shooting oneself in one's foot to not choose the maximum benefit if Mr. King did that. But because he would suffer the same consequences that my client did. But I do think that under the judgment, Judge Giordano's judgment, she intended a 50-50 division. And I think that generally, I mean, it's not a model of clarity in that respect, but I think it does require a maximum benefit to my client, which would be the maximum choice under the selection and the election. Thank you.
Thank you. We'll hear from counsel for the husband, Mr. Herrick.
Thank you, Your Honor. I'm Robert Herrick. I am here for Mr. King, and may it please the court. I will start with the pension issue because that's been the focus of our discussion. I want to start just by pointing out that the judge's ruling on this issue doesn't take anything away from Mr. CERBONE that didn't that existed in the judgment. The parties did not even litigate at trial what would happen in the event of her predecease. So the issue obviously remained silent. The judgment remained silent on that issue.
Counsel, is there language in the judgment, and I'm looking at some of it that seems to indicate the intent was to split these pensions 1/2 and 1/2?
Oh, I agree entirely, but just to make it clear, 1/2 of the marital coverture portion.
Right.
But to make it clear, this was done not as a stream of income, but as division of property.
That's correct. That is correct. I would just point out that that short of basically a buyout, I think there is ultimately a question of how one goes about dividing equally a stream of income with survivorship benefits.
No, but this is an asset, and one way of looking at it is that where federal regulations allow the recipient of that asset to preserve the benefit for her heirs and legatees or devisees, that it is certainly at least permissible, if not intended, to incorporate that mechanism.
Well, I would suggest that it's not intended, since the default rule in the CFRs is that it would revert back to the employee.
No, that's only the default rule for a silent co-op. It's not the default rule for a judgment.
Right.
That decision is left to the probate and family court explicitly, not only under our jurisprudence, but under the regulations, which quite wisely defer to state court jurisprudence.
Oh, and I agree. What I would suggest is that the judge in this situation was basically trying to put the parties on an equal footing. So
Are you talking about Judge Giordano or Judge Black?
Judge Black.
So explain to me how they're on an equal footing.
Oh, sure.
Let me ask my question.
Yes.
If there's a separate interest quadro on the private sector side, which would permit your client to immediately divide the pension and maintain complete control over it. But on the federal side, because of the somewhat now anomalistic, some might say backward nature of federal pensions, the wife is not allowed to effectuate an immediate division and has to essentially ride the coattails of the husband. Would not an equal division preserve to the wife the rights to give her share to the children in the same way that the husband would have that right under a private sector pension?
Well, I would just point out that with respect to the federal pension, he didn't have that right. And the reason was because Judge Black wanted to ensure, and Judge Giordano as well, wanted to ensure that her interest in the pension was not devalued in the absence of a survivorship annuity.
Except, well, under the federal system, the whole pension stops the moment he dies.
That's
but
correct.
At least if she retained the right in the event that she dies to leave it to her children, her share to her children would continue to get the share she would have gotten so long as the husband lives, right?
Correct, but at the same time, what happened here was that the judge recognized that there was a risk here, and the risk was that if, in the absence of a survivor annuity, that if the husband were to predecease the wife, her interest in a very substantial pension would essentially be devalued. So Judge Giordano ensured that there was a protective mechanism for the wife, and the protective mechanism was that she would receive a survivorship annuity for life, and that's
Eric,
yes.
I want to shift gears, if I may, because there's a topic that we have not yet touched upon, and that is the 60B motion. The facts or the sequence of events that I want to focus on or highlight are that Judge Black's order and rationale commented that the wife did not file a memorandum that she was invited to file. And then she went on to issue a ruling that in significant measure adopted the husband's arguments in his memorandum. The wife filed a 60B motion requesting consideration of her memo and pointing out that she in fact had filed it for whatever reason, whether it didn't reach the judge or who knows. And the action on that 60B motion was a one-word margin endorsement saying denied. You say in your brief that by all appearances, CERBONE received the relief she sought in her motion because she simply asked Judge Black to give consideration to her arguments. And I guess from where I sit, it's hard for me to understand how you can suggest that when it's a one-word denial. There's no attempt to address, engage, reflect in any transparent way consideration. Now, you point to the Code of Judicial Conduct that says that she was obliged to do so. And surely I expect that the judge performs her duties in accordance with the code. But we have nothing on this record to indicate that she gave consideration, and certainly nothing for the litigants involved, that she addressed the substantive arguments that were made.
Well, first of all, the adequacy of the record, I think, is something that this panel will have to decide. But going beyond that, what I would suggest is that there are some issues with the Rule 60B1 motion. First of all, that it's really not designed to address errors made by the clerk's office. It's designed to address errors made.
Oh no, but you can't be arguing that when a judge issues an order that explicitly states that that a party did not file a legal memorandum, that it's not open to that party who did file a memorandum to point it out to the judge and expect that they will receive some substantive response to the arguments that they had made and been chided for not making.
Well, I absolutely agree with the first part of your question, Your Honor. And that is that under those circumstances, Mr. Bone had every right and in fact an obligation to go back into court and alert Judge Black to the fact that there had been a memo filed, it was timely, and that she did not have the benefit of that in making her ruling. All that being said, the fact is, and I apologize if there was loose language in my brief with respect to the relief that was granted. Ultimately, this is framed as a Rule 60B1 motion, so it's a motion for relief from the judgment. The denial is there will be no relief. But I think liberally construed, the motion essentially is saying you didn't get our memo. Please review our memo and then grant us relief based on the legal arguments that we're making in the memorandum. The judge's denial of that motion, and it's admittedly it's a one-word denial, is a denial for relief. I believe that the presumption of regularity, the presumption that Judge Black is in fact following the judicial rules of conduct, necessarily lead this court, absent any indication to the contrary, to conclude that she did in fact review the argument and was simply unswayed by it.
Okay,
While
thank you.
we're on,
Oh, go ahead. Go ahead.
go ahead.
No, I was going to say, I appreciate your response to that question. I was going to shift gears back over to the question of contempt, because that is also a part of the appeal. But if you have further questions on the 60B, why don't you go ahead and ask those, Judge Sullivan?
I just have one very quick procedural question while we're on procedural matters. Do you agree that there was no evidence taken at the contempt hearing?
I do not agree with that. The hearing was held based on representations of counsel, and they were factual representations. And this court and the SJC have both recognized that a hearing, in an evidentiary hearing, may proceed on those grounds.
Factual representations as to the nature of the co-op?
Yes. So the primary factual representation that was made at the hearing was that the co-op was at odds with the judgment of divorce. And
That's a question of law. That's not fact.
Yeah, it's a document question. You've got.
Yeah, that's a document question. I'm asking, was there any testimonial evidence or testimonial representation as to facts particular to this case at that hearing?
I would just push back on the notion that was a legal question. Basically, there's the co-op includes language calling for the division of the entire FERS pension.
Okay.
No, the co-op speaks for itself, as does the judgment. It's a document question, and any representation that varies from the black and white provisions of those documents ought not to be given any weight by a finder of fact.
Well, it was only at the hearing that counsel for Mr. Bone went ahead and acknowledged, no, this co-op is incorrect. And what I would suggest is that is an element that supports.
That's an argument. That's an argument. That's not a statement of fact or testimony or anything else. I mean, look, we don't have the transcript. I don't want to get too far afield in parsing through what might or might not have been factual in nature, but to the extent that the focus of the contempt hearing was to identify the extent to which the co-op did or did not follow what the judgment required. That's not a question of testimony or evidence or representation. That's a question of what those documents provide.
So back to contempt. The Judge Green wanted to ask about contempt, and I'll preempt him a little bit by saying, how can a judgment that's silent on this issue be a clear and unequivocal command?
Simply because there's nothing in the judgment that, well, I should back up. There are two aspects of the contempt claim. The fact that she's presenting a co-op that calls for a division of $750,000 of the pension, when in fact she's only entitled to $450,000. These are rough numbers. Is itself obvious. It's on the record. It's undisputed. And it essentially was this poison pill that made it impossible for Mr. King to sign off on the co-op. So what I would suggest is that any finding of contempt that was based on the commandeering of the process and the resulting highly one-sided favorable to Mr. Bone co-op was itself evidence of bad faith on her part. And
well, that's an objection to the quadro. That's not I mean, I'm curious as to how that morphs into a contempt rather than an objection to the quadro as drafted.
Well, I think the fact of commandeering the process, I think the judge found that there were sharp practices that were engaged in by Mr. Bone. I think the judge is entitled to look at a past history of non-compliance with cooperation provisions. I think all of those things support a finding of contempt, and it supports a finding of contempt regardless of how this issue of the FERS pension is ultimately resolved.
You're nearing the end of your time, and I see the judge has a question.
Yes, I have two questions. The first is, you argue on page 30 of your brief that Judge Black had the inherent and ongoing authority to construe and clarify the orders. But if the order required clarification, how can anyone hold the wife in contempt?
Well, because she's not being held in contempt because of the first division. She's being held in contempt because she hired a lawyer who basically drafted a COAP that gave her $125,000 windfall, and the fact that the COAP was inaccurate and not a faithful application of the judgment was itself an element that supports a finding that she was sabotaging this process.
Your second question, Judge Henry?
Paragraph 17 says that the husband shall take whatever steps necessary to effect this provision by April 30, 2019, and that's related to the husband's pension. What's the record evidence that he took any steps by April 30th, 2019? Because she seeks to hold him in contempt.
Well, he obviously provided the information about the value of the pension. He obviously was involved in collecting the information that was necessary to come up with a co-op.
Wouldn't this paragraph put the burden on him to provide the co-op?
But what I would suggest is if you have to read paragraph 17 in collaboration or with paragraph 18, which basically imposes a burden on both parties to cooperate in going forward with this. And what I'm suggesting is that on the record that you have before you, you do not have information or the evidence that's adequate to overturn the judge's ruling.
I think we'll have to leave it there. Thank you both for your presentations.
The case is now being recorded.
The next case on our list for hearing this morning is case number 2021 P273, Kent W. PECOY versus Colony Hills Capital LLC and another. I just want to mention for the record, for the benefit of those watching us, that of course we are on Zoom and the camera is directly in front of us on the panel. However, the materials that we must consult in order to follow along with the argument are typically on other screens, in some cases, multiple screens. And if we are looking off away from the camera from time to time, it's for the purpose of consulting those materials. With that preliminary, Ms. Olenoff, for the plaintiff, you may begin.
Good morning, Mr. Chief Justice, Justice Sullivan, Justice Henry, may it please the court. The issue raised in this appeal, whether a litigant can seek relief for a claim it could have raised on appeal but did not, goes to the heart of our judicial system's important interest in finality. A decision by this panel affirming the lower court's action would have far-reaching consequences that go well beyond this case. An affirmance would essentially create another bite of the apple for litigants and would open a new avenue for parties to seek ordinary relief after an appeal has been taken and a rescript issued. After the trial in this matter in 2016, Mr. PECOY moved for and was granted an award of attorney's fees against the two defendants, the individual Mr. Hansen and the corporation Colony Hills Capital LLC. An appeal was taken by both defendants who filed a joint brief. The appeal was argued and a panel of this court issued its decision affirming the jury's decision in Mr. PECOY's favor, but overturning the award of attorney's fees against Mr. Hansen, who had argued for this relief in his appeal. Colony Hills did not raise the issue of attorney's fees in its appeal, a fact which was specifically highlighted by Justice Juno in her decision, which stated, "We note that Colony Hills does not make this argument. In fact, Colony Hills has not advanced any argument opposing the award of attorney's fees to PECOY." Thus, the award of attorney's fees against Colony Hills in Mr. PECOY's favor was affirmed after the appeal. Because Colony Hills did not seek relief from the award of attorney's fees on appeal, the argument was waived. And the post-appellate relief—
Attorney Olenoff, I often observe the difference between how we look at criminal cases and how we deal with civil cases, with the observation that the doctrine of waiver is alive and well on the civil side of the house. But the question of waiver is, it seems to me, different from the question of authority of a judge on a 60B6 motion to respond to a request for relief where it would work substantial justice. There is at least an argument to be made that it is something of an anomaly to have two co-defendants in the same case treated differently. So the question is not whether the judge could have denied the request for relief based on enforcement of the doctrine of waiver, but it seems to me the question is whether the judge had the authority to grant the request of relief despite the waiver.
Well, Your Honor, to Mr. Chief Justice, to respond to that, certainly Rule 60B does envision the situation where the lower court has the ability to affect a final judgment. However, it has been strongly cautioned that this is to be used only in extraordinary circumstances.
So why don't let me just, not to be too assertive here, but I do want to make sure that I get from you your clearest expression of an answer to my question about the judge's authority. Does the judge have authority to grant the requested relief or not, despite the waiver?
I would say yes. The judge is not limited.
So we have a judge who was well aware of the waiver, who decided to exercise whatever authority they had to grant that relief. And now it's before us on review. What is our standard of review?
Your standard of review is is abuse of discretion, Your Honor.
I thought that's right. So now that we've established those sort of predicates, I guess I'd be interested in hearing from you why, in your view, and why, based on precedential authority, the allowance of this relief in this case constitutes an abuse of that discretion.
Thank you, Your Honor. If I could point the panel to the SJC's decision in Bromfield v. Commonwealth, which states, and I quote, "It is improper to grant relief under Rule 60B6 if the aggrieved party could have reasonably sought the same relief by means of appeal." So the SJC has considered this issue, and it has said where it could have been raised on appeal, and it wasn't, it is improper for it to be addressed by the judge as relief under Rule 60B. Does that answer your question? Would you like more? I mean, that's my authority for the Rule 60B argument, that's why this is not a proper situation for this relief. If it could have been brought on the appeal, it should have been brought on the appeal. And we're not opening, the SJC certainly did not want to do.
But that was in the context where they were affirming the enforcement of waiver. I mean, if we take at face value the words that you've just recited, the answer to my previous question would be no, the judge doesn't have authority because it would be improper.
Well, I'm trying to, 60B is certainly not meant to be read narrowly. It's meant to be read broadly. It doesn't encompass, just from mistake to. I
understand, but let me while we're talking procedure here, because this is in many ways a pure question of procedure. It is also impermissible to seek relief under Rule 60B6, where one of the first three subsections would provide, and I believe it's only the first three. I don't remember. Maybe it's all. I guess maybe it's all five. I'm a little rusty on that. But you do not, as far as I can tell from your brief, make a contention that this was required to be brought under one of those earlier sections, that this is that this fits under the broad catch-all of 60B6 and no other, correct?
Well, the problem, Your Honor, is the record is silent as to why the issue was not raised on appeal. It's silent as to.
That's not a mistake by the court. That's that's inherent in the notion of waiver. So the question is. Let me ask it again. There is, that's 60B1. Are you suggesting that this request was required to be brought under 60B1, the 60B6 was not available, and therefore it was untimely because it was beyond a year?
I would suggest that if there was evidence before in the record that it was done as a result of attorney inadvertence or mistake, but we don't have that in the record. I suspect that it was brought under 60B6 precisely because the 1 year time period had lapsed, and had they tried to offer it under that subsection, they would have lost on the time limitation. So their only recourse was to bring it under 60B6. But of course, the record being silent, I can't point to any facts as to why it was not raised in the appeal, and whether it should have more appropriately been brought under subsection 1, 2, or 3.
I suppose the question from my standpoint, to ask it in a less elegant manner than Chief Justice Green has asked it, is the case is litigated, the judge makes a decision, goes up on appeal. The appeals court says to the trial judge, you were wrong. Comes back on remand. One of the lawyers, for whatever reason, didn't raise what would have been a winning issue. And the judge says, I want to fix this. Is that judge precluded from fixing it?
Yes, Your Honor, because it could have been addressed on appeal, and it wasn't. If it could have been raised on appeal and it wasn't, we're just opening the door again to continue the litigation with, instead of respecting that.
Is that a should argument or as a matter of law argument? Because if you're saying as a matter of law, then you are changing your answer.
I'm sorry, I didn't hear the last part of Your Honor's.
Are you saying that that's what the judge should do, or are you saying that as a matter of law, that's what the judge has to do? Are you changing your answer to the first question?
Under Bromfield, I say that is what the judge must have followed. The judge was not permitted to hear an argument that could have been raised on appeal, but wasn't.
So now you are in fact changing your answer to my earlier question. You're saying that the judge is without legal authority to grant the requested relief in these circumstances.
Yes, and as we were discussing this further, I realized that I didn't quite understand the nuance that Your Honor was trying to make with the waiver versus the authority. So I'm sorry. Under Bromfield, the court
So
did not have
your argument is that that under Bromfield,
yes,
the waiver deprives the judge of the ability to entertain an argument that could have been made. You know, I'm a little rusty on this too, but I seem to recall a variety of instances, including within the 60B context, where judges are allowed to revive questions that that otherwise were have been rendered final. They are not required to do so. I mean, and we have instances here where we have entertained questions that could have been treated as waived, but in the interest of justice, determined that that it was appropriate to grant an exception from the waiver rule. I'm having a little trouble squaring your insistence that that waiver is treated so rigidly here when it doesn't find that same treatment elsewhere. Obviously, the person trying to get a judge to take up a claim that was otherwise waived has a steep hill to climb and a great deal of vulnerability to a judge who says, I'm not going to let you do that. But that's different from the authority of the judge to grant an exception, it seems to me.
I think those exceptions are given in clear cases, and our case law shows these precedents when the law has changed, when something was not argued because it was not known at the time. There are these avenues that 60B is enacted to provide the flexibility of the judge to address.
Well, I don't know if you were watching, but we had a case earlier in this session where we engaged counsel for the Sex Offender Registry Board quite extensively in a substantive argument with which he was well familiar, but the offender's counsel had not raised in her brief.
And in that situation, maybe there is a counsel's mistake, inadvertence, or something that raises the question beyond a pure waiver issue. It was. I'm
not sure I know what you mean by that. I heard the words, but I'm trying to fit those into a framework that has law around it.
If an attorney has, I'm going to say this in a wrong way. If the fault lies with the attorney and not with the client, then certainly 60B provides an avenue to seek that relief. It's a 1-year limitation for them to make that argument. But that is a possible use of Rule 60B. That's not what the case is here. We don't know why it wasn't raised. That is, I think, the missing link in all of this. If we knew whether it was a mistake of counsel or perhaps it was a strategy, I don't know. We don't know. But because that issue was live, it had always been live. It was argued in the appeal by the co-appellant.
I think it's fair for these purposes to accept as a factual predicate that the attorney just didn't include a claim that could have been made.
I don't know, Your Honor, I won't concede that it is fair. We don't have an affidavit explaining why it wasn't raised. We don't know whether it was done.
Could you describe what the possible strategic advantage would be of not including the argument?
Yes, the services agreement was an agreement between Mr. PECOY and Mr. Hansen, or excuse me, Mr. Hansen was not named in the services agreement. He signed it as an officer. So if there was a strategic advantage, it was to argue that Mr. Hansen could not have possibly been included or implicated by the agreement in his individual capacity. So it made the argument against him.
That's not strategy. That's just that's a concession.
Perhaps, but again, as the record is silent.
Do you have any case post-Bromfield where a motion for relief has been allowed and either the Supreme Judicial Court or the Appeals Court has reversed that allowance because the judge lacked authority to do it?
I don't, Your Honor.
Okay. I thought there wasn't one either.
I looked hard.
I'm sure you did.
Well, there are cases that reverse the grant of relief under 60B6 where 60B6 was not available because it fit within one of the earlier subsections. But that's, I think, what we need to determine in this case. You keep insisting that it may or may not have been under 60B1, and I'm not so clear on that.
If I may continue.
Please.
I think that the other thing that we need to address here is this is not an extraordinary circumstance. Neither the trial court in its decision nor Colony Hills in this appeal offers any explanation or support for how an appellate court's issuance of a written decision in the very same case amounts to an extraordinary circumstances such that 60B6 applies. There's no support there. This was not an extraordinary circumstance. This was an ordinary circumstance of an appeal. The record establishes that the fact and the law relevant to the issue of attorney's fees was known or knowable by Colony Hills on August 30th, 2016, the date upon which the court's ruling on PECOY's motion for assessment of attorney's fees was entered. Certainly, Colony Hills could have challenged the award of attorney's fees on appeal, but it did not. There's nothing in the record that suggests that any justification, particularly where they filed a joint appeal with Mr. Hansen. So it's using Rule 60B6 as an end run around our long held rules requiring that all issues be raised in the appeal. Thank you.
Mr. Kane.
Morning, Your Honors, and may it please the court. My name is Matthew Kane. I represent Colony Hills Capital LLC and Glenn Hansen. Mr. PECOY makes essentially 4 arguments, and I would say that none of them justifies the conclusion that Judge Carey abused his discretion below in allowing.
Why don't you begin, if you would, with a response to her suggestion that that this should have been brought under Rule 60B1, and because it was beyond a year, it was no longer available.
Happy to, Your Honor, and I'll also clarify it was absolutely a mistake. You know, the question, was it a mistake for Colony Hills to not simply join in the argument appealing from that award of attorney's fees? Yes, if they had simply joined that argument, we wouldn't be here.
And what does 60B1 address?
So for 3 reasons, that's not dispositive and does not make this a 60B1 issue. And I'll explain this.
Please remind me. I don't have the rule open in front of me, but what is 60B1 address?
It's for mistake, duress, or excusable neglect, I believe, off the top of my head.
Okay, and so the relief that is being sought here, I thought I just heard you say that the relief is being sought due to a mistake. The
relief is, here's what that rule means as I understand it, okay? Colony Hills had no basis to move under Rule 60B1 because the cases that interpret that rule imply that the mistake or the neglect at issue somehow led or contributed to the entry of judgment or the order in the first place. In the Owens versus Mukendi case from the SJC, that court notes that it was not mistake that, quote, led to the entry of the judgment when they decide that 60B1 does not apply and moves on to 60B6. So if the mistake does not lead to the entry of the judgment, 60B1 is an inappropriate vehicle. Number two, even if a post-judgment—
This is the judgment after rescript, right? That we're talking with here, because that's the judgment that we now have. And the judgment after rescript was based on the appeals court decision that observed the waiver by your client.
Well, that's another way to skin the cat, Your Honor. And if that's your opinion, that the relief was from the judgment after rescript, then I moved within 14 days. It's clearly within a year, if that's the operative judgment. So either way you look at it, the result is the same. It's 60B6 applies if it's the original judgment entered in 2016. And when I say judgment, I want to be clear. This was a post-judgment order awarding attorney's fees. It is not the judgment itself. To the extent that makes a difference, I'm not sure it does, frankly.
I don't think that if we're talking about that order, that again, I'd like to think that we can get through appeals within a year from the underlying order. We are pretty good at doing it from a year after entry, but I don't think that the order brings you within the year either. I haven't looked back at that, but you can tell me.
No, it doesn't. And so the second point I want to make on 60B1 is even if a post-judgment mistake could be grounds, assume that the order that entered in 2016 is the operative date and the mistake's not made till the appeal several years later. The existence of 60B1 grounds does not preclude relief under 60B6 if there is something more. And again, that's the Owens case. And here I would argue there is significantly more that contributes to the extraordinary circumstances that would result in the absence of the relief that Judge Carey provided. That includes the anomalous result that Chief Justice highlighted in the beginning. We would have a case where the exact same indemnification provision was interpreted in diametrically opposite ways with respect to two different parties. The result of that would be that Mr. PECOY would receive a what I believe to now be over $360,000 windfall attorney's fee award with no underlying legal justification.
The mere existence of that inconsistency is not in and of itself actionable. It is, of course, as you know, possible for different parties to bring different actions on identical contracts and have inconsistent results.
It is possible, though. In my research, I could not locate a case with the exact same fee shifting provision being interpreted in diametrically opposite ways and fees being assessed against one party and not another. That would be anomalous in a way that I have not found support for.
Well, I'm also a little rusty on offensive use of collateral estoppel, but there are many form contracts that are used to enter into arrangements with multiple parties, and I certainly think it's possible for litigation, even in different states, to produce different results on identical provisions.
So accepting that hypothesis, Your Honor, the difference in this case, I think, is that here the appeals court had just read the provision at issue and said it's not a fee shifting provision. And so to go back to the trial court and have the trial court say, well, with respect to you, it is, notwithstanding what the appeals court said, I think would be anomalous. In addition, a separate factor, and I haven't talked about the BADRU case, the appeals court case helpfully kind of delineates a number of what it calls incommensurable factors that the court can consider in trying to determine whether a lower court judge abused his or her discretion. One of the factors that another case talks about, Winthrop Court versus Lowenthal, is whether the court has an abiding conviction that justice would not be done in the absence of relief. And I think implicit here in Judge Carey's order below is that he's trying to accomplish justice. As I said, a $360,000+ windfall to Mr. PECOY, coupled with a punitive a penalty against Colony Hills in the same amount is simply not just, given the appeals court's interpretation of that fee agreement. And the third reason I think that the 60B1 is not the end all here is, as this court stated in Berube, courts should be reluctant to attribute to parties the errors of their legal representatives. My mistake in not offering the same argument on behalf of Colony Hills should not result, and frankly, in my opinion, would offend principles of justice and basic fairness if the result was that a briefing error led to an otherwise unsupported $360,000 penalty and windfall in one stroke.
Mr. Kane, do I understand correctly that in addition to seeking affirmance of the relief granted under 60B6 by Judge Carey, you are also requesting in your brief an award of your attorney's fees in defending this appeal?
No, Your Honor, I'm not. Mr. PECOY is seeking his attorney's fees in prosecuting this appeal, presumably based on the same indemnification provision, which is not fee shifting.
I'm looking at page.
If I am, then I apologize. But to my memory,
page 18 of your brief. If you are now telling us that you are waiving that request and can promise us that you will not seek to undo that waiver on a subsequent Rule 60 motion, that's fine with me. But I just wanted clarification.
Now looking at my brief, I do see that I do throw that language in, Your Honor.
I'm sorry, what were those last words?
I do see that language is in there, Your Honor. I apologize.
You said throw that language in. I mean, tell me what you mean by that. Are you requesting fees or not?
No, I'll waive the request for fees.
Okay.
For the simple reason that this court has said there's no fee shifting agreement. It wouldn't be appropriate under the circumstances. And I think I probably put that in there because Mr. PECOY did. Moving on from the 60B1 argument, I'd like to address a couple of the other arguments raised by Mr. PECOY. Number one, this is not a waiver case, I do not believe. The fact that Colony Hills did not raise the argument in its appeal does not preclude it from raising the argument in a Rule 60 motion below for a couple of reasons. All of the raise or waive cases cited by Mr. PECOY arise in sort of the traditional failure to raise below means that you cannot raise on appeal context. That's not the situation here. Colony Hills did raise below prior to the first appeal.
Oh no, but there are lots of things that are raised below and then abandoned on appeal, and that the abandonment on appeals works a waiver. That's crystal clear.
I don't think that's what the cases cited say. I think it works a waiver in the appeal. If it's not argued in the brief as a matter of appellate procedural rules, it can't be relied upon in that appeal. Whether
correct. So the appeal was decided based on the fact that Colony did not make the request. It was waived for purposes of the appeal, and the case then becomes final, except to the extent that I suppose that you seek post-judgment relief.
And that's correct. And Bromfield does not hold, contrary to Ms. Olenoff's argument, Bromfield does not hold that Rule 60b6 is not permitted following entry of the rescript. Bromfield affirms the denial of a Rule 60b6 motion, holds essentially that the trial court did not abuse its discretion in denying that motion. It does say in dicta that Rule 60b6 is not a substitute for appeal. I think what that means, and the other cases that say similar things, is that if you blow an appeals deadline, you can't subsequently ask the trial court to review its order under Rule 60b6. That's not what.
Let me just, to be clear here, you are not arguing, are you, that it would have been error by the motion judge to treat the claim as waived and on the basis of waiver to deny the request for 60B relief?
I'm not arguing that because that's not at issue. And I would never argue that even if that were the result. The argument would be that the court abused its discretion. And in that case, I would not say that it was, well, I don't know. I can't go too far down that hypothetical road, but the point is that's not what happened here. It's not, an error of law can be an abuse of discretion. And so my point is Bromfield does not stand for the proposition that the issue cannot be raised post-rescript in a Rule 60b6 motion, and therefore that was not an error of law for the trial court judge to revisit that issue in the context of a 60b6 motion. Similarly, with respect to Mr. PECOY's argument that the trial court lacked authority, that's plainly not true. In the case of Resendez, cited in my brief, kind of explains why. That's a case that was judgment entered for the wife, the husband appealed, the appeals court affirmed, rescript entered, a subsequent decision came out of a Maryland appeals court that required the wife, didn't require, but prompted the wife to go back to the probate court and file a Rule 60b6 motion to amend the order, to change it from finding that a particular prenuptial agreement was not fair or reasonable to holding that it was actually null and void. And that the probate court did that, and the appeals court, this court, affirmed that on appeal. Clearly, if the probate court had lacked authority to reopen that judgment, that case would not have been affirmed. So I don't think there's any question that Judge Carey had authority. I think that addresses each of the arguments in PECOY's brief. I would urge the court to look at the factors in the Berube case. I think a number of those strongly tilt in favor of affirmance here. Those include the magnitude and the consequences of the order, the clarity with which it appears that the order was unjust, the equities in terms of the interests of reliance, and the court's own convictions about justice. If you put those factors against the facts of our case, as I've mentioned previously, we have a very significant dollar figure in play here. And in terms of the clarity, the appeals court said there's no fee shifting award, no fee shifting provision in the services agreement. So it would be very clearly be unjust to give PECOY that windfall. Mr. PECOY, in terms of reliance, has not argued or advanced any facts to suggest that he relied on that award of fees or changed his position in any material way based on that award of fees, such that he would be unfairly prejudiced from the vacating of that award. And it's under these circumstances, certainly my conviction that justice required vacating the fee award. I infer that Judge Carey shared that conviction, and I hope that this court will also share that conviction. Unless there's any other questions, I'll just close by asking that you show Judge Carey's exercise of discretion the marked deference that it deserves, and that you affirm the order vacating the award of attorney's fees. Thank you for the opportunity to be heard and for your consideration.
Thank you both. The case is submitted.
The case is now being recorded.
The next case on our hearing list this morning is case number 2021 P294, ECCOS Energy LLC and another versus Judith Judson and others. I will remind those viewing who may not have been here for the opening of one of our other cases that we are, of course, using the Zoom platform in recognition of the increase in infections during the pandemic. That means that we are in front of computer terminals with cameras. We are generally staring at the camera and staring at the screen where the camera is located, but from time to time we need to consult the briefs, record appendices, and other materials which are on one of several other screens that we have available to us. And from time to time, if you see us, as you see Judge Henry at the moment, looking away from the camera, it's because we are consulting those materials. Mr. Malone, you are the appellant. You may begin your presentation.
Thank you, Your Honor. Good morning, Your Honors. The plaintiffs here applied in November 2018 for what is known as a Statement of Qualifications, or SOQ, from the defendants for the plaintiff's proposed solar project in East Long Meadow. An SOQ guarantees a 20-year offtake arrangement for the electricity that a solar project produces under the smart solar tariff filed by National Grid. Under the defendant's regulations, the SOQ was required to be issued if 3 conditions were met. There is no dispute that 2 conditions were met. The dispute here focuses on the 3rd condition, which required the plaintiff to submit evidence of all necessary governmental permits and approvals to construct the facility, with the exception of ministerial permits. The sole issue here related to satisfaction of the 3rd condition was the terms of the town of East Long Meadow's bylaws, which then, as now, purport to allow ground-mounted solar systems only in their industrial districts, and the plaintiff's property is not in those districts.
So, counsel, I have a preliminary question, which seems to be assumed by the parties, but I wanted to hear both of you say. Does annulling the town bylaw at issue necessarily itself demonstrate that ECCOS had obtained all necessary government permits?
Yes, it does, Your Honor, because the only other permit, well, there were 2 other conditions that would have needed to have been met. The building permit, which is a ministerial permit, and then site plan review, which is a non-discretionary permit. And in the consolidated statement of facts, the parties agreed, it's actually consolidated statement of fact number 17, which I believe is in, well, it's in the joint appendix, that site plan approval itself was non-discretionary. So
what was that
or,
page number?
let me just see. So that is A36.
Okay.
Statement of fact number 17. And so the parties disputed or did not dispute, and they agreed that site plan review is ministerial as well. So
Mr. Malone, at the time you submitted your application, in fact, you did not have a permit or an entitlement to a permit by virtue of the bylaw provision that you have since challenged. Is that correct?
well, I guess, Your Honor, to me, that depends on whether you view the law at the time as valid. The bylaw is valid.
Well, I mean, what at the time the state of the law was that that you did not comply and you were not entitled to a permit. You lodged a challenge to that provision, but at the time that you submitted your application, that law was on the books and had not been set aside. Is that correct?
That's right. At the time, the law was on the books, had not been set aside.
So under the strict language of the regulation, you did not satisfy that 3rd requirement. And I'm not going beyond or going outside or denigrating or ignoring the other arguments that you make in your brief, but I just want to set a couple of foundational predicates. Let me ask a separate question, because if you included this information in the briefs, or I always hesitate to go outside the record, but this is a matter of judicial notice. Is the land court judgment now final, or is it? Has there been a notice of appeal? Where does it stand? Can you tell me? Give me any insight on that question?
Yes, Your Honor. We filed the final judgment as an addendum to our reply brief, and no appeal was taken.
So I missed that. I'm sorry. All right. And my 3rd question is there any impediment to your ability to reapply with that judgment in hand and to satisfy all 3 of the regulatory requirements?
We could reapply. The problem, if we reapply, we would get a lower compensation rate for 2 reasons. One, because of all of the applications that the department has approved since the land court made its decision. And
so there is no regulatory obstacle to reapplying. You may suffer some disadvantage had you been entitled to a permit when you first did apply.
Well, there's a second reason we would be disadvantaged, is because the department changed its rules. The original rules would be what's called the Class 1 facility. And under the new rules, if we were viewed as submitting a new application, we're only a Class 2 facility.
Okay, but I guess I'm struggling a little bit to understand the practical implications of what it is that you're asking us to declare, because a regulatory agency, if I understand your argument correctly, would be compelled to grant your application based on an inchoate legal argument that removes one of the obstacles to your eligibility for that permit. Is that a fair statement?
Well, Your Honor, I guess I don't agree with that because
Well, the agency denied your application before the land court judgment entered, correct?
Correct. That's right.
So I'll say it again. A regulatory agency would be required to grant a permit based on an inchoate argument that, if successful, would remove one of the impediments to eligibility for that permit. That's what you're asking us to do. And I understand that there's some benefit to you in being able to jump the line from the perspective of timing and fixing your rights, and there can be all kinds of other things that can happen in intervening events, but that does not, it seems to me, justify a contention that whether it's a zoning board of appeals or a planning board faced with a subdivision application or anyone else that is asked to overlook a requirement based on an as yet to be decided legal challenge. Seems to me that's the whole purpose of the third requirement, that you have to get your ducks in a row before you submit the application. What am I missing?
Well, I mean, the language of the third requirement says we have to have all necessary approvals. And our contention, and the land court agreed, was that at the time we did not need, or we did in fact have all approvals we needed.
At what time? At what time?
Well, the land court decided in August, and their view was the law was clear. The statute that we cited to Dewar was clear on its face, that the town had no right to prohibit our project. So I guess I would say that at the time we applied, state statute was clear. This was not an area where the town could prohibit our project, but yet the town ignored that.
So your contention is that in the face of a bylaw provision that you contend is unlawful, you can expect the regulatory agency to adopt that argument prior to adjudication of that premise and grant you a permit, and you can go forward without lodging a challenge to it. I mean, under your argument, you would have been entitled to get the permit and get started moving forward, even without bringing the separate land court action, right?
That's right. That the department could have determined what was a necessary permit. Just like with requirement number 2, they make a determination as what is a sufficient interest in land. They're the ones that have to take the evidence that's submitted and then make some threshold determination. I mean, the example that we gave in our brief is that, what would the department do if the bylaw discriminated based on race and said, well, if you're X race, you don't need a special permit. But if you're a different race, you do need a special permit. Now, the way the department ruled in our case, they would say, well, we have to respect that racial discrimination. And my argument in that case, as here, would be that no, it wouldn't, because what they're trying to uphold is unlawful in that case, and the land court said that it was.
Are you arguing that the illegality was as apparent in this situation as in the example you just gave based on race?
No, I wouldn't say it was as apparent, but the land court did characterize it as clear.
Yes, but that was the result of an adjudication. I mean, with all due respect to your example, the law on the question of racial discriminatory regulations is really quite well established. And it seems to me that there are many, many other instances where the law could be subject to arguments on both sides. Now, I have not looked at the bylaw provision in sufficient detail to determine whether it was or should have been apparent to the department that it was unlawful or illegal, even without the land court. But it seems to me that that's where you have to get.
Well, I agree. In both cases, the department's regulations require the determination of a necessary government approval. The only one that can make that determination is, in fact, the department.
But where there is a bylaw, a local bylaw provision that explicitly prohibits the use, unless the illegality or invalidity of that bylaw provision is absolutely apparent without any further proceedings, it seems to me that you're stuck with that until you get it set aside.
Well, yeah, I mean, I guess my view is that it was clear based on the statute, because the statute at issue basically prohibits a bylaw from stopping a number of uses on specific property, whether it's an educational institution, a farm, or a solar facility. That statute in all those paragraphs says that the municipality cannot prohibit that type of use on a person's property. So
I have a number of questions and I want to make sure we get them. So first of all, did you refile at the point that the land court issued its decision?
I believe we did refile, yes.
Okay.
And then what happened was the department basically took the position, despite the fact that we have in the statement of facts 17, the agreement that site plan approval was a ministerial permit. The department then took a contrary position, which is also contrary to every other project that they have ever approved. So they denied it again. And so I guess in one sense, if we lose this case, then we have to challenge the resubmission, because the department just changed their view entirely and took a position contrary to what was agreed in statement of fact 17.
Well, yeah, but let's not anticipate that appeal. I mean,
right.
Accepting the premise of that, that gets into a question of what the local site plan review process is involved. Judge Henry has more questions.
In your brief at page 16, you argue that the department's failure to review the bylaw under some standard was clear error, but you also argue that their failure to adequately explain the decision was also clear error. Are those two separate and independent arguments, or are they joined together in some way? Are they like a 1A and a 1B?
I think they would be a 1A and a 1B. It's basically the review of the decision itself under administrative law principles.
So the department argues it would be a separation of powers violation for the department to evaluate that zoning law. And in fact, that this is reserved to the exclusive jurisdiction of the land court. What do you say to that?
Well, I mean, there's a state statute which says municipalities cannot regulate this area. So the regulation itself is drafted by the department. So this is their rule that they empowered themselves to make the determination. And so I don't understand their point when they say they have to respect a bylaw without even thinking about what it means in the face of the state statute, which says the bylaw can't do what it's doing.
I take it you agree that you did not bring a challenge to the decision under Chapter 30A. You are just pursuing this separate declaratory judgment action.
That's correct.
Okay. So the department argues if they're required to hold applications in abeyance while you litigate around the issue of this town bylaw, that the whole program would come to a halt, which definitely would be undermining of the goal to move to solar facilities. What do you say to that?
I don't agree with that, Your Honor, because, at least in our particular case, the delay would have been only 4 months. And even if the department continued to process applications, which, would be fine, there was still room in August when the land court rendered its decision to put us in the spot where we would have been. If that were not the case, then the department, it seems to me, should have said, well, all right, we can't put you in the place you would have been in, but based on the land court's decision, we will put you in the place now, as if we were going to approve your project then in August 2019. But they didn't do that. They just held on to their decision, which was based on an erroneous conclusion.
So what do you say to the department's argument that property law usually applies prospectively?
Right. So in terms of property law applying prospectively, the key in those cases, as far as I can tell, is that other parties have relied on, in this case, the unlawful bylaw of the town. There's no one else has relied on that, as far as I know, and the department offers no examples of other people that have relied. In fact, if the department put us back in the position where we should have been, then no one is harmed. No one in the queue gets bumped down. No one gets a lower compensation rate. The only person that's harmed is us, and we believe that's contrary to the program or the policy of the program.
Judge Henry, do you have any further questions?
No.
Judge Sullivan?
No.
Thank you for your presentation.
Thank you, Your Honor.
The department.
Thank you, Your Honors. May it please the court, my name is Kendra Kincher. I represent the Department of Energy Resources and its commissioner in this matter. I want to be clear that there are several facts that the parties all agree to. They're all set forth in the plaintiff's complaint, and the key agreed facts require the Superior Court to dismiss the plaintiff's claims. Those facts are as follows. The plaintiffs agree that solar energy is an important public interest. Both parties are seeking to promote solar energy. The parties agree that the SMART program provides a voluntary and key financial incentive to help develop that. But in order for a participant to apply to the program, it must meet the regulatory requirements at the time that they submit their application. The only issue here, as Attorney Malone stated, is whether they had all necessary governmental approvals at the time that they submitted their application. At all relevant times, including today, the plaintiffs admit that at the time they submitted their application in 2018, the town prohibited, under its zoning bylaw, the proposed facility from being constructed on plaintiff's property. So they clearly do not meet the plain language of the regulations.
But today, with the land court judgment final, we know that that prohibition is no longer a factor, right?
Correct, Your Honor. I will note, however, that the precise legal question that the land court has decided in this case, while a final judgment here, has just been taken up by the SJC in another land court decision. It's Tracer Lane Realty versus City of Waltham, SJC 13195. This is a question that has not yet been decided by appellate courts.
But for purposes of this town, I can't comment on what factors may have led the town to proceed on appeal or not. But at least the state of the law now, since they didn't take an appeal, is that they are bound by the land court judgment, and there is no other attempt to regulate or prohibit this use in that district. So there is no legal impediment validly on the books in the town today.
Correct.
To prevent the plaintiff from applying for and obtaining a building permit for this use on this site.
Correct, Your Honor. And as a result, today, not in 2018, but today, they could apply to DOER for the program and they would be issued an SOQ. I want to be very clear about the intervening application was prior to the land court's final judgment. And the town reached out to DOER and stated to DOER that the project was still prohibited, that they did not have all necessary approvals. And just as DOER is not going to look behind the zoning bylaw, DOER is going to take the town at its face for stating that the project was still prohibited on plaintiff's property. And so DOER again was faced, they initially approved the application, but once the town made that statement, and again, none of this is in the record before your honors, but we would be happy to supplement it. Once the land court's judgment was final, 2 years after their application, they were then able to submit an application and it would be approved if they still met all of the other regulatory requirements.
So, but is ECCOS correct that the department disclaimed any review of the bylaw under any standard?
Yes, Your Honor, and that's what we stated in our brief. DOER has no authority, and plaintiffs cite no authority that would enable DOER to independently review a zoning bylaw. It is not allowed by their enabling statute, which is Chapter 25A, Section 6. It is not allowed by the separation of powers doctrine, which prohibits an executive agency for undertaking judicial functions. And it is not allowed by Chapter 240.14a and Chapter 185, Section 3, which places the exclusive jurisdiction of determining the validity of zoning bylaws in the land court.
Okay, so accepting that, he gives this extreme example of a town bylaw that prohibits a person of a particular race from developing their project. And are you maintaining that the department would still deny the SOQ in that circumstance?
Your Honor, again, that's an extreme example, and one in which
it is an extreme example. But under your argument, he's right. He's given an example, and you're saying we can't possibly review any town bylaw, even one that expressly discriminates based on race.
As Chief Justice has indicated, there is a wealth of case law, final judgments of the SJC and the Supreme Court that says that it is unconstitutional for that to happen. In addition, the Attorney General's office.
Well, which one of the unconstitutionalities trumps? Because I cannot believe that you are telling us that the department would allow a bylaw that discriminates based on race to be enforced.
Correct, Your Honor.
Really, that's the position that you want to take, that you as a state agency would honor a bylaw that expressly prohibits, that expressly discriminates based on race?
No, Your Honor, I just stated that there is a final judgment that states that those bylaws are unlawful. Not only the SJC, but the Supreme Court and the Attorney General's office would strike that down so that it was not on the books. So the DOER would have what has happened since in this case, a final judgment of a court indicating that it is an unlawful bylaw, so that it does not independently need to evaluate that bylaw.
And you're basing that on what? On like a past court determination?
Yes, Your Honor. And that's what the plaintiffs should have done here. They just got the timing wrong. They should have applied to the land court as they did here, received a final judgment invalidating the zoning bylaw, and then applied, because then at that time they would meet DOER's regulatory requirements.
Would it also have been, go ahead.
Why should it be, I can understand why you would say that they should apply after the land court has issued a ruling, but I'm not fully following the after the land court has issued final judgment, because you do have people who are trying to get in a line for changing financial incentives. And it does sound like from the briefing, correct me if I'm wrong, that people can get their approval and then still drop out. So why wouldn't this just be like that?
You need a final judgment in order for that to be a final determination of a court. A summary judgment decision could have been appealed by the town, and so it could have been not a final determination by a court. And all of the cases that talk about the doctrine of retroactivity are applying a final judgment of a court, not a summary judgment decision. And the regulations are clear that you need to have those approvals and the authority, the ability to construct the solar facility at the time that you apply.
Is there a procedural avenue that is available to allow an applicant in circumstances such as these to file an application and to ask that the application be held in abeyance while they prosecute a clear challenge to the validity of an otherwise prohibitory bylaw?
No, Your Honor. The regulations require the applicants to be able to construct the solar facility at the time. And the reason for that is that DOER needs to have an efficient ability to manage this program. There are many applicants to the program, as is shown by the record. And as the justices have indicated, it is a declining program. And so essentially what applicants are trying to do here is to be spot savers, to save a spot in line that they weren't entitled to. They need to do their due diligence in advance, as they would for any other, that they would have the property right to be able to construct here, that they have an agreement with NSTAR or with any other local utility company. You have to have your ducks in a row, as the justices have indicated today, before you apply, so that you're not prejudicing other projects that can be constructed today.
I understand the response. As a practical matter, it occurs to me that what that has the effect of doing is providing an incentive for local municipalities to adopt patently impermissible prohibitions and to leave it to those municipalities who do not do so to be the subject of applications by different applicants who just happened to fall in those jurisdictions. And eventually, if you want to carry it out, the numbers could wind up precluding, as a practical matter, the projects that are proposed in the municipalities that adopted impermissible bars and reward that misconduct. Am I missing something?
That misconduct can be challenged, but it can only be challenged in the land court. So
the effect of that is that all of the trains leave the stations in all of the communities that don't enact those provisions, and by the time the land court challenges, let's say that there are 15 communities out of the 350 some odd cities and towns in Massachusetts, the 15 cities and towns that run out the clock on the litigation in the land court wind up having succeeded in preventing these projects from crossing into their boundaries, because they engaged in, and I should be a little more careful. I use the word misconduct, but they adopted bylaw provisions that were patently impermissible under the entire regulatory framework that the DOER had put in place.
Well, I would first indicate that I don't know that it is patently impermissible, just by virtue of the fact that the SJC has taken this up on appeal. 40A Section 3 allows for reasonable regulations. And so that is a very amorphous phraseology that is going to be considered. What does that mean? What does that mean? What can a town do and not do when regulating solar industries under 40A Section 3? That is not something that DOER should be forced to have to determine on its own.
Let me ask a different question. The AG's office still conducts regulatory review of local bylaw provisions as they are enacted, and those that are, to use my term, patently invalid are rejected. Is that correct?
Correct, Your Honor.
Under
And
the
so
section 5, is it?
I don't recall off the top of my head. That's a separate section of the Attorney General's office than mine. And so in the instance of a discriminatory bylaw, that would have been rejected by the Attorney General's office. That would not have gotten on the books.
That's not a final determination of validity, but it at least passed through that filter to get to this point where it was challenged in the land court.
Correct.
But to go back though to his hypothetical, you're saying that discriminatory bylaw based on race would not have gotten passed.
Correct.
You're saying if it had gotten passed, the department wouldn't apply it because generally the Supreme Court, because there's other law out there that you know about that would strike it down. But his argument is, well, there's other law we know about here that would say that bylaw is impermissible. So I'm struggling to see the difference.
There was at the time that this was submitted, there wasn't an appellate court decision or a final judgment of the land court indicating that this was unlawful.
There was a statute though, I think is what his argument is.
40A section 3 allows for reasonable regulations of solar in local zoning bylaws. It is my understanding that the town took the position and the land court in a prior case, not this case, had ruled that it is permissible and a reasonable regulation to allow zoning in certain zoning districts and not others. So it is not the case of a discriminatory bylaw that it was a clear and unequivocal unlawful bylaw. And in addition, with respect to the retroactivity argument, changes in property law are normally applied prospectively. Oh, I see my time has expired. I would just like to wrap up by indicating that the clear provisions of the regulations were not met in 2018 when they submitted their application. So the plaintiffs requested relief, a declaration that they did meet those regulations in 2018 could not be granted by the Superior Court.
I think we can leave it there. Thank you. Thank you both. The case is submitted.
The case is now being recorded.
That brings us to the fifth and final case on our hearing list today, case number 2021 P296, Eleanor Epstein and another versus the members of the Planning Board of the Town of Marblehead and another. Just as a reminder for those who have not seen the other arguments on our hearing list this morning, I want to remind everyone that we are on Zoom due to the pandemic. We are looking at the other participants in this hearing at cameras mounted on our workstations. The content that we are consulting during the course of the argument appears on a different screen. If we happen to be looking away from the camera, it's typically for the purpose of consulting those materials. With that, Mr. Duffy, you may begin your presentation.
Thank you. Good afternoon, Mr. Chief Justice and members of the panel. May it please the court. My name is Michael Duffy. I represent the plaintiff and appellant Jay Epstein in this case. This is a case where the court can clarify and uphold longstanding precedent in a land use arena that presents as more obscure and complicated than it really ought to be. The land use approval at issue is a site plan approval. The site plan approval in question is one issued by the Marblehead Planning Board, authorizing the private defendant, Mr. Jacobs, to demolish an existing house and to erect a new and different one in its place. The plaintiff is aggrieved by that approval because the planning board failed to apply correct procedures or criteria And more specifically, the planning board failed to require the applicant minimize adverse effects on abutters. Marblehead's bylaw provides, and this much is not in dispute, that site plan approval is subject to special permit procedures with the express reference to General Laws Chapter 48, Section 9. Thus, a principal legal question before the court in this appeal is to determine what imposing special permit process must mean in this context. Plaintiff's position, and we think this is inescapable, is that calling for special permit process or procedure in site plan review means that the procedures afforded in Chapter 48, Section 9 are to be applied. The most minimal of those procedures in the statute, apart from notice and opportunity to be heard, is that the board create a detailed record of its proceedings, setting forth clearly the reason for its decision and of its official actions. This minimal requirement was not satisfied here in this case on any objective view of the facts.
The site plan review, go ahead, Judge Sullivan.
No, go ahead, Chief.
Site plan review has a fairly complicated history in Massachusetts. It's of course not recognized under Chapter 48. There are several different flavors of site plan review. Sometimes the Zoning Board of Appeals is a site plan review conducting authority. Sometimes it's the Planning Board. Sometimes when the Planning Board does so, it does so as an antecedent to the issuance of a building permit, but without specifying the local bylaw special permit procedures. But there's a lot of law out there on this, and certainly there's no discretion, as there is under Section 9 for a special permit for site plan review for a use otherwise allowed as of right. You agree with that, I assume, Mr. Duffy?
Yes, Your Honor.
Okay, and the question of the procedure of the board really has no authority to deny site plan review except at the margins, right?
Yes, Your Honor. The board has authority to impose reasonable conditions on a site plan approval.
Right. So I guess at the threshold, there's very, very little of Section 9 that comes into place. They are required to issue a decision, and you are required, if you want to challenge that decision, to file your appeal within 20 days, et cetera. But what aspect of the decision I thought you were challenging the decision on substantive grounds and not on the four corners of the form of the decision itself?
Well, our challenge is, Your Honor, that there is no evidence before the court, was no evidence before the trial court, that the planning board conducted itself in accordance with the Marblehead zoning bylaw, or that it applied the criteria that are required under the provisions governing site plan approval. The only
trial court, do you mean trial court or the zoning board? I mean, the
first in the first instance at the planning board, and then again upon de novo review before the trial court. In terms of the planning board, Your Honor, the only evidence that we have of what the planning board did in this proceeding is the decision itself. And in that decision, the planning board addresses mandatory criteria under the Marblehead zoning bylaw. And we know this is mandatory criteria because we have this court's decision in Muldoon versus Planning Board of Marblehead that the planning board is required to apply these criteria, one of which is that the planning board consider the extent to which the adverse effects on abutting lots, the immediate neighborhood, and the town of Marblehead are minimized, including such as but not limited to conflicts between residential, commercial, and industrial uses, obstructions of views, increases in the use of town services, and impact on town infrastructure. Insofar as a consideration of that criteria was undertaken at the planning board, we looked to the decision, and the decision that the planning board issued addressing this mandatory criteria is embodied in two sentences. The first of those sentences is a verbatim recitation of the language of the bylaw criteria itself, something that this court has repeatedly held to be insufficient.
If I may.
Yes.
Because we've all read those two sentences and we're already at 9 minutes. Am I correct in my understanding that you think that the board failed to take proper account of the impact of the project on your client's views, the 5 windows?
Yes, Your Honor.
Is that what this boils down to?
It does, Your Honor, and as this matter
Okay.
comes forward, we have no evidence that any of that consideration was made because we can only
All
look
right.
at the decision.
And then, but here is my question with regard to that. Massachusetts is one of several states that permits de novo review in the Superior Court. And if the issue is the balancing of the view versus the other factors, the Supreme Judicial Court has said, and I'm quoting from the Roberts case, on appeal to the Superior Court or the Land Court, a judge determines the legal validity of a zoning board decision on the facts found by him. He gives no evidentiary weight to the board's findings. Your brief concentrates quite heavily on the board's findings, and I am somewhat perplexed by that because I read Roberts to say that in effect, any findings or lack thereof at the board level dissipate if not disappear, and that what we look at is the judge's findings, and the judge's findings here were fairly complete with respect to the view. Have I gone amiss somewhere?
I would only elaborate Your Honor's correct citation of the law with one significant detail, and that is that a de novo review at the Land Court or the Superior Court really involves two questions. The first question is a question about whether the local board has applied correct procedures, law, and bylaws. And that is a question of whether the local board decision is legally tenable on its face.
Right,
And
but
if-
based on the facts found by the judge. So let's stick with the facts found by the judge, not the perceived defect in the factual findings of the board. How are based on the factual findings made by the judge, is the board's decision legally untenable?
The board's decision is legally untenable because it didn't apply the criteria. The board's decision is also unreasonable, which is the second prong of the de novo review, Your Honor, because of three main issues. The first is that the trial court made a clearly erroneous finding of fact concerning the location of a leafy green tree in the plaintiff's view shed, which affected the court's findings and conclusions about whether adverse effects had been minimized. The second is that the trial court's interpretation of the bylaw language regarding the meaning of minimized is erroneous, in that it fails to interpret the term consistent with its meaning in ordinary usage. The trial court interpreted minimized.
So counsel, your opponent is going to argue in a minute that when we consider minimized, the problem with your argument is it's just from your client's perspective, and that minimized has to consider other abutters on the public who use the street, and that having the house where it's being proposed is better, particularly for anyone member of the public that's using that street. So what do you say to that? Why is he wrong?
He's wrong for two reasons. One is that that is not taking into consideration what the court's actual findings were in this case, and the court's interpretation of the statute, which was to interpret minimized to mean not maximized, which is plainly wrong. That can't be the case. The second reason why that's incorrect is because there's absolutely no testimony, law, or any basis to state that that the purpose of the bylaw is to provide vistas down the street as parties would travel down the street or walk past the street. The purpose of the bylaw in minimizing adverse effects is to minimize adverse effects to abutters.
Mr. Duffy, there's a fair body of law with which I'm sure you're familiar that recognizes the particular familiarity of local regulatory boards in land use matters with the conditions of the neighborhood. And while the trial court conducts a de novo review as to the facts, there is a great deal of discretion extended to the balancing of interests that necessarily becomes the subject of the board's review of a particular application. And I don't think, at least I'm not aware from, I used to do a little bit of this stuff. I don't remember there being any requirement that the abutters' interests that take priority over everything else. I think that the ability of an abutter to come in and challenge is based on their ability to demonstrate that they have a particularized injury that gives them standing. but they're not entitled to a priority weighing of their concerns in the overall administration of the local board's duties.
Yes, Your Honor. There's no evidence that the local board did that weighing, at least not in the decision, and that's what we have to look to. And our argument is not to supervene any other considerations of any other parties by the plaintiff's needs and wants here. We argue also in the brief, and this was the case at trial, that there was evidence before the trial court that there could have been a change to the location of the defendant's house by shifting it closer to Crown Way by 5 feet, which would have had no impact whatsoever on the defendant's programmatic design, and would have had the impact of further lessening the impact on the plaintiffs. And this, in view of the language of the bylaw, which requires that the planning board consider that adverse impacts have been minimized, would indicate that there was a change, an easily available change to the defendant's plan that would have further reduced the adverse impacts on the plaintiffs. Now, that wouldn't have supervened any other party's interests. It wouldn't have even derailed any aspect of the defendant's plan and design and architectural concept. It simply would have relocated the house 5 feet closer to the street. And that would have been a correct, perhaps even laudable balancing of the competing interests of the defendant in developing the property and the abutters and the protection of the abutters' interests. That should have taken place.
Is the board allowed to consider the benefits of setback and front yard requirements?
The planning board is absolutely allowed to consider those in determining whether adverse impacts could be reduced. In fact, consider Muldoon, the appeals court decision out of this court, where the planning board imposed a condition that required an even greater side yard setback than what was required under the zoning bylaw. And that imposition on a site plan approval was upheld in the appeals court as being a valid exercise of the planning board's authority. That authority existed in this case just as well. The planning board could have imposed a condition that the approval was approved subject to sliding the footprint of the house 5 feet closer to Crown Way.
I know whether or not there's a 70 or 75-foot setback is in dispute, and maybe what you're suggesting is that the case might resolve on that basis, but leaving that aside, just because on your view of the law, the board could have ordered that, does that mean that the board was required to order that?
No, it does not mean the board was required to order that. It does mean, and I think here's the fundamental crux of the argument, there's no evidence the board considered any of those issues at all. And it was a requirement that the board consider adverse impacts. We have nothing.
Then now we're getting back to, go ahead.
Go ahead.
You were getting back to the quarrel over the form of the decision and the level of detail. I mean, these are volunteers, typically. I don't know about Marblehead in particular, but typically these local boards are volunteers. They write their decisions. They are required to give a statement of the reasons, but the statement of the reasons doesn't need to go into the level of detail that it seems to me you are saying is required in order for it to survive review.
That's why you get de novo review in the Superior Court or the Land Court, is to get that level of detail, arguably.
My argument is that special permit procedures applied. And that meant that there needed to be a detailed record that needed to be clear as to the reasons of the planning board's decision. That requirement wasn't met here.
Even if you're right about that, let's say you're right, and let's say that they didn't give the detailed reasons they were supposed to give. There was still de novo review in the trial court, and all those detailed reasons were given. Where's the harm?
Well, the harm is
the reversible error.
But the court was wrong on 3 issues that I mentioned before, Your Honor, and these were argued in my brief. I
just don't see how your detailed review under Section 9 survives the de novo review in the Superior Court. And if you have a brief answer to that, I'd be delighted to hear it.
My brief answer is to refer the court to Josephs versus Board of Appeals of Brookline, 362 Mass 290. In that case, the SJC did a thorough review of both decisions made at a board level and at the trial court level, and both proceedings were important to the result of that case.
Thank you. Thank you. For the board?
Good morning, good afternoon. I actually represent the private defendant.
I'm sorry.
Actually,
Yeah.
Robert Jacobs, trustee of 11 Crown Way. Town council filed with the planning board that he was going to ride, the board was going to ride on the coattails of the applicant.
I'm sorry.
No problem. There's no legal or factual basis to disturb Judge Rubin's decision upholding the Marblehead Planning Board's grant of site plan approval. Mr. Epstein went to the planning board. He made his objections known to the planning board. Now, you've heard Mr. Duffy say, well, how do you know? How do you know the planning board heard him or considered him? I actually read the decision that was presented by the planning board quite differently. I know that the planning board considered each of the requirements they have to consider, because the first thing they did is they enumerated each criteria that they needed to consider in their decision. They put it in their decision. And then after that, they made a subsidiary finding which helps understand their reasoning. Now, I understand that Mr. Duffy reads that second sentence to have absolutely no meaning at all. To me, I think for lay people, they did a phenomenal job explaining their reasoning as to why they balanced that there was no adverse effect to the abutters, the neighborhood, and the town. And they said that they were replacing an existing home, which was non-conforming, with a conforming home in two material ways. One was to bring the height down by 9 feet. And the second way was to actually locate the house further away from the appellant, from Mr. Epstein. And secondly, they said there was careful attention paid to the scale and the form of the proposed home. Well, what does that mean? Scale is the size, form is the design, what the house looks like. So they said, look, we're satisfied that we've considered there's no adverse effects to the abutter, to the neighborhood, and to the town, because this house was designed well with regard to its size and how it's going to look and how it's going to form. It also made findings, the planning board also made findings with regard to how the house was oriented on the lot to better conform to other houses on the street. And it made other detailed findings throughout its decision. The notion that we don't see any evidence that the board did their job is just not supportable by reading the decision. It just is that the argument makes, it just doesn't withstand scrutiny. I think that I'm not going to spend a lot of time on, the quality of the findings, but I just want to pick up on a point that Chief Justice Green mentioned, and that is the level of findings relates to the substance of the decision that the body is being asked to make. Site plan review does not have the discretionary components of a special permit, even though it's called a special permit in some municipalities. We know that. The case law has made that clear. Merely calling something a special permit.
What's your best case for that proposition? That the case law makes it clear that calling it a special permit doesn't really change?
Prudential. It's
okay.
Prudential versus Westbrook, if I remember correctly. I'm sure we cited the Prudential case in our brief.
You did.
Okay. That
parties are in dispute around the setback requirement, whether it's 20 or 25 feet. Is that a question of fact? Because you seem to be arguing about the orientation of the ocean and the lot lines.
No, that the issue of whether or not there's a 20-foot setback or a 25-foot setback is a question of law as to how the bylaw works. We lay out in our brief why it's a 25-foot setback. There is a specific.
But no decision maker has said what it is, right?
Well, the planning board said what it is, because if you look at the site plan that they approved and you look at the exhibit, there is a box showing the zoning requirements. It says the front yard requirement is 25 feet. There's an asterisk, and it explains why that asterisk denotes this reference to this particular bylaw change. So the planning board understood that there should be a 25-foot setback.
So I understood him though to be saying it sort of depends on which line you're using, and so that there was, based on the layout of this property, there's a factual component. Is he wrong about that? Am I understanding?
No, the only factual component is all of the lines that are perpendicular to the shoreline require a 25-foot setback. Mr. Duffy says, well, the two side yards are the most perpendicular to the shoreline. They have a 25-foot setback. Side yards have a 25-foot setback anyway. That is the setback requirement on side yards. There is the front yard where it's undisputed. Mr. Duffy's own expert testified that the front yard, the front line is perpendicular to the shoreline too. And then there are some portions of the rear yard that are perpendicular. And you will see on the site plan that as a result, and the particular bylaw that requires this, the front yard setback is enhanced from 20 feet to 25 feet, and the rear yard setback is enhanced from 15 feet to 25 feet.
Well, the question of whether it's enhanced or degraded is one question. The separate foundational question is, what is the requirement? And it seems to me that the requirement as applied to this site is a mixed question of fact and law that involves some level of interpretation of the bylaw definitions of what those setbacks are and how they're measured.
I think it certainly is with regard to, you have to make a determination that the lines that you maintain need to be enhanced and have a 25-foot setback instead of a 20 have to be perpendicular to the shoreline. That fact has to be shown, and that fact is clearly shown in the record, and it's undisputed. Mr. Duffy's own witness testified to that. But here's what's important, and I think the judge got it exactly correct. The planning board did not have, even if the setback was 20 feet, the planning board did not have to put in a condition that said, you must move the house back 20 feet. And now Mr. Duffy just explained his view why nobody is harmed by that. And I'll just offer to the court, well, that's Mr. Duffy's view. I could suggest to you that the community would be harmed because that house would be 5 feet closer to the street, more imposing on the street. And the whole reason why in the Marblehead Shoreline District, they have this enhanced requirement that your front yard can grow from 20 to 25 if it's perpendicular to the ocean or to the shoreline, is to create a vista to allow someone that's on the public street to have the houses set further back from the street so you can have a vista of the shoreline. That's what Muldoon says. That's exactly why the court in Muldoon said it would was the purpose for that shoreline district enhancement. I'll also note that Mr. Duffy didn't accurately report the holding of Muldoon. Muldoon didn't say it was okay for the planning board to require a condition. What Muldoon said to Judge Shire in the land court was, it was not a per se violation for the planning board to say you can have a more stringent setback requirement. So Judge Shire said, the planning board has no power to do that as a condition. Per se, they cannot make the setback requirement greater. And the appeals court said, no, we're not going to go that far. We're not going to say that was a per se requirement. The planning board can do it, but that doesn't mean it makes it a reasonable condition. And that's all that Muldoon said. It said that Judge Shire's view that there was a per se prohibition for the planning board was inappropriate. The bottom line.
What about the tree? We know that the tree was erroneously placed. So what was the significance to the tree in the decision from your perspective?
The significance of the tree in my decision is that the court observed that there was this large tree there, and that tree had some impairment of the view corridor that Mr. Epstein wanted to preserve anyway. It wasn't the only impairment. There were other impairments. There was the existing structure of the carriage house that she pointed to, the garage structure. There was the deck structure in the house to the left. And I think the court's point simply was, look, this is not a pristine view to begin with. The fact, and the tree was there. There's no dispute of fact. No one's saying the tree isn't there. The fact that the judge, when she wrote her decision, said the tree is on Mr. Epstein's property, when it actually sits on the property line, but it's on Mr. Jacobs' property, right on the line, it's just not material. It didn't matter. What mattered to her was there was a tree there. Now, what Mr. Duffy tries to do is jump into the judge's mind and say, aha, the judge said that there was a tree there. The tree was on Mr. Epstein's property. He wasn't cutting down the tree. So, you know, his view was impaired by a tree that he could have cut down. And Mr. Duffy spins this entire, you know, articulation of what may be going on in the judge's mind, none of which appears in the judge's decision. I think it's just completely made up. I think what is simply is this: there is a tree there, matter of fact. No one's arguing that there's a tree there. And that tree had, and the judge was commenting on the quality of the view before the house. The fact of the matter is, the judge couldn't have been clearer after taking into account all of the testimony, including, the judge said, including the expert testimony that Mr. Duffy presented, as well as looking through the precise windows in the Epstein's home that Mr. Epstein was so concerned about.
The judge, unless I missed it, the judge did not take a view in this case, right?
Just the opposite, Your Honor. The judge not only took a view, but went not only took a view, but went into the Epstein's house, went into every room, looked out of every window, including the 5 windows that were in this case, and looked out the windows herself.
Just out of curiosity, how did this case wind up in Norfolk?
Well, it went from, it's in Essex and Marblehead, and it went to the land court. I don't know why it's.
Okay.
I don't know the reference to Norfolk.
Right. All right. I saw that on the decision. Okay.
So to finish my point simply, there's just the argument that the planning, we have no way of knowing that the planning board considered things. It's belied by the decision they wrote. With regard to Justice Sullivan's comments, she's 100% correct. We have de novo review in the Commonwealth. That basically says start all over again. Applicants like my client, we had to prove our right to this site plan special permit all over again in front of a judge who can make their own independent findings and not rely on anything that the planning board said and apply those findings to the criteria. Judge Rubin wrote a 20-page decision that I think carefully and very, very appropriately did just that. And so to suggest that there is some legal basis for a problem either at the planning board level or at the land court level on this particular case is not found in this record. The last thing that I would say is that please remember, site plan review, where we do have a lot of case law, is very, very clear that it is not to give an opportunity for someone to take an otherwise use which is allowed by right, the single family home in this case, a use which has been presented fully dimensionally conforming in every way, shape, or form to every dimensional requirement of a zoning bylaw, and then suggest because a neighbor has their particular interest that, gee, my view is being impaired more than I would like it. It wasn't even being eliminated in this case. The plaintiff didn't even have the opportunity to go in and say, I had a view from this window and now I have no view. In every window, there will continue to be a view of the shore of the ocean. It's been diminished, no question about that. And it's been diminished in the eyes of the planning board in a way that did not require the planning board to condition the proposed application. And in the eyes of the judge who saw it with her own eyes, was minor and insignificant. And I'm sorry that Mr. Epstein feels that everybody else has it wrong, but he doesn't have a view easement. He doesn't have a right to impair my client's ability to build a single family home in the design and style that my client would like to do after my client goes through all of the requirements of the Marblehead zoning bylaw, complying in every dimensional requirement, and the planning board giving him the site plan review the planning board was supposed to do after duly considering, not being required to make findings in Marblehead. And I asked you to look at the Presiding case that we cite in our brief. There was a big difference between the requirement to make findings and considering the criteria. In Marblehead, it's just considering the criteria. My time is up. I appreciate the court's attention.
Seeing no further questions from the panel, that concludes the argument in this case. And with it, the argument, our session, the case is submitted.